Dr. Shadi Maganoe, Senior Lecturer at the Wits School of Law, joins us now to unpack all of this. Thank you so much, Doc, for your time. So help us understand what's at stake here. I mean, we have the interdict served on Parliament on Friday seeking to stop the impeachment committee from continuing its work while the courts consider the president's challenge to that 2022 report. Now, at the same time, we've been hearing from opposition parties, including the ATM, opposing the president's application. Let's start with what's actually at stake on the 15th and the 16th of July. I mean, does this create a complex constitutional and legal landscape? Perhaps also maybe start with what exactly President Ramaphosa is asking the courts to do through this interdict application.
Hi, and thanks for having me. I think remember that this is the first time we are using some of the laws that we have in our constitution in order to start the impeachment process when it comes to impeaching the president. So we are basically moving on uncharted waters because we are putting our constitution to the democratic test. So what the president is asking here is that the High Court should put a pause or a temporary pause on the parliamentary impeachment process while he continues with the review of that Section 89 panel report. He's not saying that that impeachment process shouldn't continue. He's just saying, can we please pause this process while I review the very foundation of that process, which is that report. Because remember, in his application, what he argued is that if that report is set aside, every decision that came from that report should also be set aside, which would mean if the High Court is able to set aside that Section 89 panel report upon review, what he would actually also be asking is that any decision, which would mean that impeachment process, should also be set aside. So the High Court can grant that interim interdict, but I think it's important to be precise about what is actually being interdicted. Yeah. The court is not reviewing or suspending the Concourt's order, and it's not stopping Parliament from implementing that order. The challenge is directed at that Section 89 panel report itself. So the president is seeking to set that report aside based on the grounds of legality. So he's not necessarily saying set aside the Constitutional Court order.
Yeah. And then, of course, there were questions around urgency. You know, the president had ample time to then set this application forward. What do you make of that timing that some of the MPs, of course, the impeachment committee members have also been, arguing about in terms of the timing?
Exactly. So if you would remember, the review process started in 2022. Yeah. So he didn't proceed with it after the Constitutional Court said it can't be the court of first and final instance. So he's coming back again to review, and then he's also now decided to interdict the other processes that flow from the Constitutional Court decision. So some may argue that it's being done in bad faith, it's a delaying tactic, but we can't necessarily prove the reason why he waited this long. And in order to be successful with that interdict application, he would have to prove that there's a reasonable risk of irreparable harm if that process is not paused, so that he can continue with his review process, which is a constitutional right that he's entitled to.
Yeah, I don't know how much of that virtual meeting you heard. I mean, we have the ATM, Vuyolethu Zungula, arguing that the president has no reasonable basis to fear unfair treatment from the committee itself. How persuasive do you think that is, that argument is in law? I mean, I think second to that, could the court conclude, that the president should first participate in the process and only then challenge any procedural unfairness if it arises later?
So the court cannot necessarily make a decision to tell the president to first go through the process and then apply afterwards. Because remember, he's already been granted permission to review the report. So the interdict is basically him coming before the court urgently to say that please pause this process because I have a prima facie right that to apply for this interdict, and that if this process is not paused, it will pose an irreparable harm on my constitutional rights, and there's a balance of convenience that favors me as the president to say that you need to pause this process. So the court would have to hear that application separately from the review process in order to determine whether there is going to be irreparable harm or not if that process is not paused. So practically his strongest case is the principle of legality. in this instance. And the biggest hurdle is that the courts are reluctant to halt parliamentary process unless there's a clear constitutional defect.
Yeah, I also just want to go back to, what some of the political parties belonging to the impeachment committee have been saying. Part of it, of course, also questioning the role of the speaker, so to speak, in terms of what should she be doing now that the ball is in her court? I mean, committee members arguing that, the speaker already cited as the first respondent to formally now oppose that interdict. What then should happen? Should the speaker firstly, side with the political parties and say, actually, it will be opposed, or, what can she do constitutionally?
So constitutionally speaking, remember that impeachment committee is basically a branch of the National Assembly. So it cannot litigate on its own. It's relying on the speaker to either oppose that application, which would be to defend the legality of the process and parliamentary autonomy. The speaker can also choose to abide by the court's decision. So she can take a neutral stance and allow the court to determine the issue. And I think it's also important to remember, because I just said she can, by she, I mean her as the Speaker of the National Assembly, not in her personal capacity. And then what the Speaker can also do is file explanatory papers to explain the procedure and compliance with the Constitutional Court order without fully opposing. So she has a discretion guided by institutional responsibility and also constitutional compliance. So she can either oppose, as the impeachment committee is saying. She can file papers to abide by the court's decision, which would be a neutral stance, or she can file explanatory papers to say that this is the process and this is the Constitutional Court order, and not necessarily oppose the process in that sense.
I suppose it's a case of waiting to see what happens tomorrow, given that deadline is on the 19th of June for the impeachment committee and Parliament, in fact, to make that decision. But thank you so much, Dr. Maganoe, for just unpacking all of that for us, of course, saying there that it is uncharted territory we again found ourselves in. All right, let's take a quick break. We'll be back with more news.